The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
In spouses Binjola will support the tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tingnan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised
embark on a retrenchment program only if it was experiencing actual losses. Not necessarily. In the words of the Supreme Court, if the employer can perceive that sooner or later the economy of the company will go down to the drain, then it should do something. The employer of the company should do something. It should not wait anymore for that time or period that the employer or company incurs actual losses.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
What is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
course, in cases filed against you, you don't merely avoid conviction. Of course, there are some things that you would also have to consider. First, the time. Second is the investment. Third is the opportunity. Fourth is your peace of mind. And fifth is your personal wealth. So out of the 100 targeted accounts, hackers were able to reset 45 user accounts' passwords. Now, these hackers
be very fast in saying, yes, I want to go fishing with you, because this person might be talking about a different kind of fishing, a fishing that will lead to a criminal offense and probably put you in prison.
Does not fall under the Data Privacy Act if it is an information pertaining to an entity that is not a natural person. Consent must be something that is mechanical and tangible. It must be proven. That is consent that is required under the Data Privacy Act. You have to prove that you have obtained the consent from a data subject. So who may wish to have some questions, probably they can send their questions to the Villasis Law Center and we'll try to answer them.
Three things, no? We were reminded by the National Privacy Commission that the cardinal rule, if you talk about processing of data information, is that do not collect if you cannot protect. The primary impact of the Data Privacy Act, my friends, are the 8 rights provided by law. Very important. There are 8 rights here. You talk about the right to be informed, the right to access, the right to erasure or blocking, the right to object, the right to rectify. You talk about data portability, the right to file a complaint, and of course, the right to damages. Data is more valuable than money because if someone takes your money, that's all they have, okay? But if you let someone take your data, oh my God, eventually they will take your money too.
So does the DPA only cover personal information per se? Or does it also cover information about companies, testing results, and...
Hi sir, good
Hi.
evening. Sir, just a question about the DPO officer. Is there such a thing as a void or not valid DPO officer appointment wherein even though the NPC has properly recognized his appointment?
We will be having our second quiz.
Just kindly, enter the link in the chat box, okay? So we can get started. So I think a little bit of an icebreaker is in order. Can we bring out the wheel?
Yes, we will do again a raffle. Congratulations! Ronaldin A. Urban.
on Civil Procedure. Okay, diretso. Yung 2020 Rules on Civil Procedure were promulgated by the Supreme Court precisely, my friends, because of the Supreme Court's rulemaking power or the power of Promulgation 1, actually. So let me begin, my friends, no? So, if you will read the amendments, actually, if you will study it carefully, you will realize that there are how many areas here? Only 9 areas to consider, okay? What are these? Amendments under the rules on pleadings. Pagkasama-samahin ko na. Rule 6, 7, 8, 10, 11, and 13. The number 2, amendments, no? Under Rule 10 on amendments. Okay? Important changes introduced to the rules on amendment under Rule 10. What else? Amendments under the rules on summons. Rule 14. Okay? What else? Amendments under Rule 15 on motions. Amendments, of course, introduced to Rule 18, pre-trial. Dito, marami po. Ayan. And of course, Rule 30, trial, my friends. Finally, there are amendments also that should be discussed under Rule 33, my friends. Okay, under Rule 33, demerit evidence, and of course, judgment on the pleadings under Rule 34 po yan, Rule 34. Okay? And of course, summary judgment, Rule 35. So let us enjoy our journey towards the rules on civil procedure. Notable changes in amendment under pleadings, specifically talk about the rule on verification. Di ba? Yung verification po, yung attestations niya, expanded na. Bakit? Okay? I'll start, my friends, no? By first, ganito. Di ba yung sa verification, who must sign the verification? General rule, the party must sign the verification. Certification is from shopping, the party must sign. The certification is from shopping. That is the rule. Okay? Pero paano if the party is an individual? Okay? And he executed a special power of attorney, SPA, authorizing another individual to sign the verification is not allowed. Di ba? What if the
VLC Warriors, please visit and subscribe to Villasis Law Center YouTube channel. Together, we can make things happen. Together, we can. Good attendees, pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The virtual, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team
will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our virtual law companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer has obtained his Bachelor of Laws as class valedictorian from Cagayan State University. He is enrolled in the Master of Laws program of San Beda University Graduate School of Law. Prior to finishing his law degree, he finished Bachelor of Science in Nursing and Masters of Science in Nursing from University of St. Louis in Tuguegarao City. He is an acclaimed speaker and oralist. Some of his achievements include 9th Best Oralist in Stetson's 21st Annual International Environmental Moot Court Competition Final Rounds, in Florida, USA. In 2017 he was awarded a provincial commendation for being the 3rd best oralist in the 4th Southeast Asian Regional Rounds of Stetson International Environmental Moot Court Competition. As an educator, he teaches political law review and constitutional law at Cagayan State University College of Law and a national nurse lecturer for nursing licensure exam and NCLEX. Currently, he is the University Risk Control Officer and Deputy University Secretary of Cagayan State University. Without further ado, please welcome Professor Rafael de la Cruz III.
Okay, so good day everyone again. We're going to discuss now the updates in political law. So ang format natin from 2020 down hanggang 2019 and 2018, some 2018 cases. But along the way, I'm going to discuss with you several cases na dinicide ng Supreme Court that is in relation to those cases that they have decided now. No? So one of the controversial cases now released by the Supreme Court recently in September of 2020, although it's dated August 26, 2020, is the case of PICAB versus Manila Waters. Okay, so let's see whether the provision of the IRR on PICAB would be declared as constitutional or unconstitutional by the Supreme Court. Okay, this PICAB versus Manila Water Company is a very good case. The provision in question is Section 3.1. The regular license shall be reserved for and issued only to construction firms of Filipino sole proprietorship or partnership with at least 60%. I would like to highlight this provision, 60%. Okay, so the question now, will this PICAB possess the authority to grant or to delimit the percentage of these partnerships and other corporations or proprietorship to secure the regular license? That is a very important question. Why? It's because consistent sa atin. Diba? It should be Congress, upon recommendation of NEDA, okay, nagagawa ng mga areas of investment in which yung mga certain percentage as to Filipino or other percentages kung ilan yung pwedeng maging allowable percentage of Filipino ownership in that specific area of investment. Now the question now, meron bang authority si Philippine Contractors Accreditation Board on the same? Simple lang ang kwento. Si Manila Water Company humihingi ng regular license sa PICAB. Dininay ng PICAB because according to them, hindi sila pasok doon sa requirement para magkaroon ng regular license. Okay? So, ang question ngayon, meron ba talaga siyang authority? Now, ito yung contention ng PICAB. Section 14, okay, of the Constitution, Section 14 of Article 12, clearly provides the sustained development of reservoir. Wag na doon. Yung pinaka-importante yung nasa baba. The practice of profession. The practice of profession in the Philippines shall be limited to the Filipino citizens save in cases prescribed by law. Ito yung logic ni PICAB. If you consider the securing of license, more specifically, the regular license, as a practice of profession in the Philippines, then it shall be limited to Filipino citizens. That is actually the one invoked by PICAB. Simple yung logic. Pag practice of profession, yung pag-secure ng lisensya, talagang Filipino citizens lang. So yung ginamit nila na save in cases prescribed by law, ang ginagamit nila na law dito is the one creating the PICAB, Republic Act 4566. Ang question ngayon, meron ba silang authority or wala? Okay, please take note. The clear letter of the law is controlling and cannot be amended by a mere administrative rule issued for its implementation. Make no mistake, this has been a consistent ruling of the court. Remember the case of Lokin versus Comelec, nung dinagdagan nitong Comelec yung isa sa mga ground nila for substitution, nilagyan nila nung withdrawal. Wala naman dun sa batas mismo. So ang point dun, the administrative rule cannot supplant the very law which it springs of its authority. So in short, the administrative rule cannot in any way contravene the law that created such. Okay? So please take note. This section 14 of Article 12, it must be noted, the privilege of natural person to exercise his profession in the Philippines. Ang tanong ngayon, yung corporation ba, pag kumuha ng lisensya, practice ba yon ng profession? Exercise ba yon ng profession? Ang sagot ng court, ito. Under Article 4 of Republic Act 4566, even partnerships, corporations, and organizations can qualify for contractor's license through its responsible officers. The profession under the said provision sa 4566 refers to the practice of natural persons of a certain field in which they are trained, certified, and licensed. So, look at the last phrase. Being a licensed contractor does not automatically qualify within the ambit of the Constitution as profession per se. Simple logic. Sa 4566, yung term doon na profession is not the same with the constitutional context of profession. So yung practice of profession na tinutukoy doon sa Republic Act 4566 in which PICAB has full authority to regulate does not in any way conform, or if not, it does not equate to the very wordings of Section 14 of Article 12. Yung profession doon, hindi yon yung nakalagay sa 4566. In short, hindi siya, yung PICAB is walang authority, okay, to regulate that profession under Section 14. So ang tanong na lang dito, since wala siyang authority to regulate that type of profession under Section 14 of Article 12, meron ba siyang at least delegated authority from the law to classify these licenses? Ang sagot ng court, meron naman. May authority ang PICAB to classify licenses. But the classification of licenses must be set forth in the very law itself. Unfortunately, yung paggawa ng national-based license, it's not part of Republic Act 4566. So it again countermands the mandate of the law. Sa 4566, ang nakasulat lang is yung mga general license and special licenses and the like. Wala doon nakalagay authority to classify national-based licenses. Which, of course, ito nga yung ginawa ng PICAB. Nag-classify sila based on national index, di ba? So ginawa nila yung mga 60% prescinding from the Omnibus Investments Act. The Supreme Court have said wala kayong authority to do the same. Therefore, the Supreme Court declared Section 3.1 of the IRR of PICAB or Republic Act 4566 as unconstitutional. Okay, make no mistake. Gusto nyong sagutin ng ganong perspective? Magaling. Okay yon. So isang atake, you focus on Section 14 of Article 12 and simply mention the profession that is mentioned here does not cover those practice of natural persons. So yun yung magandang sagot doon. Or kung gusto mo naman, tirahin mo siya in this perspective. The areas of investment, the determination of areas of investment is a congressional prerogative. It is a legislative prerogative upon the recommendation of NEDA. Unfortunately, PICAB is not part of the legislative. Perforce, the action of PICAB is ultra vires and unconstitutional. Pwede na yung ganong atake. So, this ruling gives us two possible legal bases. Article 12, Section 14 of the Constitution, the last part of which, and of course, okay, yung pinakamaganda is yung doctrine na lang natin that this determination is a legislative prerogative. Okay? So, pwede yung ganong atake. Okay. So, ito lang yung simpleng question dito, no? Who has the power to determine certain areas of investments which must be reserved to the Filipinos upon recommendation of NEDA? Claro, Congress. Okay? So, if you want to impress your examiner, simply write it there. PICAB is not part of Congress. Okay? So, therefore, it has no authority over the same. Okay. So, meron lang ho. Now, we go to this one important controversial case. Saire versus Honorable Sinos. GR number 24413-24415-16. February 18, 2020, Justice Karandang. Again, I will highlight this. This is a good decision, but there appears to be another dissenting opinion registered, okay, by Justice Kagiwa. Question. Ano ba yung issue dito? Di ba? Nung kasing dineclare ng court na unconstitutional yung provision sa Republic Act 9165 relative to the prohibition on plea bargaining, okay, on drugs cases, ang sinabi ng court in that celebrated case of Estipona versus Judge Lobrigo, the Supreme Court have said that that usurps a judicial prerogative. What is the judicial prerogative alluded to? It pertains to the rule-making powers of the Supreme Court. Okay? So sabi ng court, this action of the legislature is patently unconstitutional because it usurps that judicial prerogative. Okay. So ang tanong ngayon, anong nangyari nung na-discuss ng court yung Estipona versus Judge Lobrigo in that April of 2017 ruling? Ang nangyari ho, nagkaroon ng parang it's a sudden gush of plea bargaining cases ngayon sa lahat ng regional trial courts natin. Why? It's because lumabas yung Administrative Matter 18-03-16 or OCA Circular Number 90/2018. Ano ho yung nakalagay doon? Ang nakalagay doon is pwede kayo mag-plea bargaining. Of course, may mga requirements doon. I will leave that to your very brilliant criminal law professors. Ang klaro lang doon is that kapag halimbawa may sale of drugs, pwede silang mag-plea bargaining into possession of drug paraphernalias. At yung provision doon, yung penalty clause doon, mababa, medyo mababa. May discretion ng court from 6 months to 6 years. So in short, whether kunin mo yung maximum 6 years, probationable pa rin, di ba? So that was actually the action of the Supreme Court in adopting the Office of the Court Administrator recommendation, more particularly number 90/2018. So, ito namang mga akusado, ang nasa utak nila, kaysa ma-life imprisonment ako, dumiretso na lang ako ng plea bargaining. That was actually the impression. No? So, ang problema ngayon ito, in the Estipona versus Judge Lobrigo ruling, maliwanag doon that you have to secure the consent of the prosecutor. So what happened? One of the issuances of then DOJ Secretary Aguirre is Department of Justice Circular Number 27. Kung titignan mo yung DOJ Circular Number 27, yung penalty clause doon, medyo hindi tugma doon sa ni-recommend ng Office of the Court Administrator. So meron doon, pag sale of drugs, parang nasa 12 years ata yung penalty provision niya, no? So ang tanong, anong masusunod? Yung 12 years ba na nakalagay doon sa DOJ circular? Or is it now the AM number 090-2018? Anong susundin mo? Is it the DOJ circular or the issuance of the Supreme Court? Okay. One of the petition, of course, the petitioner rather in this case, si Saire, needed Okay? Wants to have this plea bargaining rather. No. Humingi siya ng plea bargaining. Unfortunately, the DOJ consented, but the penalty should be the one prescribed by the DOJ circular. Ang problema ngayon, syempre ayaw din ng akusado. So pinipilit ngayon ng akusado na magkaroon ng plea bargaining. So ang prosecutor naman gumawa ng continuing objection. Ang problema, hindi nagkatugma. So sinet ng court ngayon for pre-trial. Ganun pa rin ayaw talagang magtugma. Umangat na ngayon dito sa Supreme Court. The question is simple. Did DOJ Circular number 27 amend, repeal, or at least revise the AM matter number 18-03-16 of the Supreme Court? In simple terms, are these two issuances of two independent, separate constitutional bodies contradictory with each other? Yung in-issue ba ng DOJ, sorry, klaruhin ko lang hindi constitutional body ang DOJ. Okay? Yung in-issue ba ng DOJ, kinontra niya yung in-issue ng Supreme Court? Okay, I want to hear your points. Okay, so kung nabasa niyo yung kaso, well and good, alam mo na yung sasabihin ko. Pero pag hindi mo nabasa yung kaso, baka naman pwedeng tulungan mo ako mag-isip. Comment mo dun sa baba. Okay? Ilagay mo dun. Do you agree with Saire in contending that this DOJ circular usurps the judicial prerogative of promulgating the rules of procedure? Make no mistake, in Estepona versus Judge Lobrigo, the Supreme Court have said that this plea bargaining scheme is deemed to be part of the revised rules of criminal procedure, which is part of the rules of procedure. This rules of procedure is exclusively within the domain of the judiciary. Ang tanong, in the guise of this DOJ circular, did it really amend that specific provision in AM matter number 18-03-16? Okay. Justice Karandang have said it did not. Okay? So it did not amend. Ang tanong ngayon, ano ang gamit nun? One thing is for sure. The Supreme Court again reiterated, the plea bargaining provision is a matter addressed to the sound discretion of the court. Okay, so what does that mean? Since it is addressed to the sound discretion of the court, it is not a matter of right on the part of the accused to get the same. Okay, so that was actually the ruling of the court in that case. Okay, so please take note. And I want you to please, kunin nyo na lang yung mga keywords dito sa kasong to, no? I like this phrasing of the court. DOJ Circular number 27 merely serves as an internal guideline for the prosecutors to observe before they may give their consent to the proposed plea bargainings. Okay. This is now the inference that we can get. It will not bind the court. It will only bind the prosecutors because it's an internal guideline. Okay? Here is now the problem created by this ruling. So paano kapag halimbawa, nag-object si prosecutor? Tapos, in-overrule ni judge yung objection ng prosecutor. Grinant niya yung plea bargaining. Is that constitutional? Oh, let's wait and see. But these are the rulings na medyo associated dito. In Estepona versus Lobrigo, the Supreme Court have said that the consent of the prosecutor is a condition precedent for plea bargaining. That's the problem. So the discretion of the court appears to be delimited by that ruling in that Estepona case. So parang condition precedent siya. Without the consent of the prosecutor, the plea bargaining will not be approved. Okay? So, those are matters na magiging contentious issue. And let's wait for the Supreme Court to settle again kung meron tayong actual case or controversy. Okay. Now, At the risk of being redundant, I want you to look at this phrases utilized by the court. No, the acceptance of an offer to plead guilty to a lesser offense is not a demandable. It's not demandable by the accused as a matter of right, but it is a matter addressed entirely to the sound discretion of the court. Now, I would like to emphasize the word entirely to the sound discretion of the court. Lumakas ba ang court sa ruling na to? Yes. So apparently, para may conflict, no? Condition precedent yung yung consent ng prosecutor, tapos entirely to the sound discretion of the court. Ang tanong, anong masusunod doon? Let's wait and see for the Supreme Court to settle this case. Okay, ito yung problema kasi doon sa petition ni Saire. Sa petition ni Saire, it's a certiorari proceeding. Yes, di ba? Pag certiorari proceeding, you have to prove what? Grave abuse of discretion amounting to lack or excess of jurisdiction. So in the last part of the ruling, ang sinabi ng court, we cannot attribute grave abuse of discretion on the part of Judge Sinos for setting the case for pre-trial and of course subsequently to the trial stage. What was the reasoning of the court? Again, sinabi nga ng court, it merely serves as an internal guideline. The DOJ Circular Number 27 only serves as an internal guidelines po. Okay? So baka naman inaantok-antok tayo dyan. Galaw-galaw tayo, ha? Isipin mo lagi ito. Kapag inantok ka dun sa mga lectures, hindi lang sa lecture ko, sa mga lectures ng mga kasama ko sa VLC, isipin mo, what if pag bigla kang inantok yung sinabi niya, yun yung lumabas sa bar? Anong tawag doon? Oh, anyway. Diba? So, ingat lang. Isipin mo lagi, kapag may mga nagle-lecture sa harap ninyo, you should be grateful. Lalo na pag may nasabi sila na mga kaso na at least parang makakatulong sa atin. Alam mo kasi, ito lang ang prinsipyo ko eh. Di ba? The more you study, the more you discover your ignorance. One best part of studying is of course to listen to lectures. Okay? So kung ako sa inyo, kung tinatamad na kayong magbasa at ayaw nyo nang gamitin yung mata ninyo, then perhaps makinig na lang ho kayo sa lecture ninyo. Sa mga lecture po namin. No? So kung halimbawa nakikita nyo yung mukha ko, parang naiirita ka na sa mukha ko, hayaan mo lang. Ang importante naman yung sinasabi ko. Hindi ko sinasabi na lalabas lahat yung sinasabi ko sa bar exam. So ang sinasabi ko lang, posible hong lumabas sa bar exam. And in this case, the Saire versus Sinos, it is one of the case na sigurado kong tumatak dun sa utak nung posible magiging bar examiner, magiging bar chair ho natin. Okay? So, si Justice Kagiwa ho, registered his strong dissenting opinion in that case of Saire versus Sinos. The question is, why did he register? Konting background ho. Si Justice Kagiwa is a former Department of Justice Secretary. Make no mistake, former DOJ Secretary. And according to him, the DOJ Circular Number 27 is contrary to the provisions of the plea bargaining framework, drafted no less and approved by the Supreme Court through the Office of the Court Administrator. That being the case, it usurps the rulemaking powers of the Supreme Court. So ito lang yung point. If you want to side, of course, you have to side with the majority because as you always say, di ba? The decisions of the court are not final because it is infallible. It is infallible because it is final. So kahit na may dissenting opinion, kahit na may mga magagandang views, dun pa rin tayo sa majority opinion. So dalawa yung way para pag-atake natin, no? So merong yung answer natin sa majority is that internal regulation lang yon that will guide the DOJ personnel or the DOJ prosecutors. Pero kung gusto mo naman, an alternative answer is that, of course, you can say that it is usurping the judicial prerogative because it is contrary to the plea bargaining framework approved by the Supreme Court. So those are two ways of answering. But to me, of course, you have to go first to the majority opinion before you go to the minority view. Ang punto ko lang ito. Knowing the elephant within the room is the best way to know how to pass the exam. Simple lang, di ba? Kung ikaw yung magbibigay ng question, ano yung mga questions na ibibigay mo? Simple. Yung mga cases, questions na tumatak sa'yo. Anong? Di ba? Kung nag-register ka ng dissenting opinion mo, kung nag-register ka ng separate concurring opinion mo, ibig sabihin, may something sa majority na parang hindi mo gustong i-conform. Or meron kang ibang way of reasoning dun sa ganong klaseng kaso. So, ano yung mas tumatak? Yung dinisentan mo o yung niregister mo as dissent? So, think about it. Even sa law school, kung gusto ho ninyong pumasa, dun sa mga professors ninyo, aralin nyo yung mga professors nyo. Kaya sigurado ko ngayon, yung mga estudyante ko, inaaral na ho ako. Okay? So anyway, ang problema, pag inaaral nyo ako, isa lang yung dapat tandaan ninyo. Pag inaral nyo ako, kayo din ng mga estudyante ko, inaaral ko. Okay, so, moving on. Okay, we now have the case of, okay, ito to me, the ruling of the court in this Bishop Amari case, the subsequent case. Again, it's a 2020 case, February 17 of 2020. Ito yung keyword dito. Isa kasi siyang part ng isang religious group, no? Ngayon, tinanggal siya. Ang tanong doon is whether or not it violates a secular standard or it violates a sectarian standard. Now, I have to emphasize this because this is a good it is a good consistent ruling of the court. While the state is prohibited from interfering in purely ecclesiastical affairs, the church is likewise barred from meddling in purely secular matters. Now, share ko lang sa inyo. Ito kasi is a question on, it's a question more of, ano yung dapat masunod? Secular or sectarian? Now, I will give it in a way na magkakaroon ng framework yung utak ninyo kapag ganito yung facts or situation na binigay ng mga bar examiners natin. Okay. 2 words na gusto kong kahit papanong lalaruin ninyo. Number 1, secular standard. Number 2 is sectarian standard. Okay? Now, alin dito yung ecclesiastical? Pag sinabing ecclesiastical, it has something to do with the exercise of religious belief. For obvious reason, it is not secular, it is sectarian. Okay? Now, mapapansin nyo naman yung gusto nilang palabasin dun sa issue natin. Dito, yung pagkatanggal sa kanya, ano ba yun? Is it really termination or expulsion? Why am I trying to emphasize that? Because if that is only expulsion, okay, in-expel lang yung tao, that is entirely within the domain of that specific sector. What is the reason? It's because it springs from their right to discipline its members. Hindi papakialaman ng state yan. Okay? So that is sectarian perspective. But, taking its cue in the case of Austria versus NLRC, if that is an issue of termination, that is a violation of a secular standard. Pag na-violate yung secular standard, then this sect cannot invoke this doctrine. Okay? So that being the case, ganito lang ho. Tignan ninyo yung action ng gobyerno. The government is to further a secular interest. A government cannot establish, okay, sectarian interest. So what is in between? That's the principle of accommodation. What is the limit of accommodation? Simple. The limit of accommodation is that yung action ng government should not advance or it should not establish, okay, a sectarian interest. Likewise, this sectarian or sectors rather cannot violate or prohibit any secular interest. That's the limit of the doctrine of accommodation. Okay, alam nyo? Sige, tandaan nyo lang yan. Screenshot nyo na lang ho. Pag nag-enjoy kayo o kaya natututo kayo sa lecture natin, baka naman ho pwedeng mag-comment tayo ng VLC. I-share natin tong video na to. Okay. Now, ikalat ho natin ha. Ikalat ho natin yung information na meron tayo because yun naman ho talaga ang gusto ng Villasis Law Center. Okay? Ang gamit ng Villasis Law Center is to help. Extend a helping hand to those who is in need of information. So tulungan po natin sila, pa-share po natin yung video. Maraming salamat po. Okay, so alam nyo, kung ganito, kung na-master mo yung format na yon, dadaling ka na yan eh. Tingnan nyo ha. I'm going to give you cite different cases relative to the separation of church and state. Ito, discuss natin tong kasong to. Itong si Bishop Amari versus Villaflor. Tinanggal siya. Tama. Pero ano ba yung pagkatanggal sa kanya? Ano yung nature ng pagkatanggal sa kanya? Ang nature ng pagkatanggal sa kanya is not termination. It is expulsion. So this expulsion or the act of expelling that person is within the domain of this religious sector. Therefore, the issue now is, did it violate any secular standard? The answer is no. Walang na-violate na secular standard kasi hindi naman termination. Ano nangyari dito? Expulsion po. A right ng every sectarian, ng every sector to discipline its members. Right nila yon. Pag pinakialaman ng gobyerno yan, anong effect? The effect is the government is already advancing, okay? Or it is already furthering an important sectarian interest. That being the case, it is already in violation of the establishment clause, the prohibition against establishment clause of the Constitution. So please take note of that. Now, para mas madali nating maintindihan, pagbangga-banggain natin yung mga kaso. Remember that case, issue. Sasabihin ko naman yung kaso. Ganito yung nangyari. Paano pag idinimanda mo yung isang municipality at yung constituents ng municipality na yon, puro Muslim. Ang nagdemanda, Muslim. Ang dinimanda niya, isang municipality na puro Muslim. At yung mayor ng town na yon, Muslim din. Okay? Question. Pag dinimanda nitong petitioner, nung complainant na to, itong municipality na to, sa Sharia court, will that case prosper? In simple terms, may jurisdiction ba yung Sharia court? Oh, what do you think? Oh, comment it doon sa ating comment section. Ilagay nyo doon. Ano yung sagot nyo? May jurisdiction ba ang Sharia court or wala? Make no mistake. Magkakaroon ng jurisdiction ng Sharia court in this perspective kung parehas na Muslim. There is no doubt. Yung complainant, Muslim. Wala tayong question doon. Tapos sabihin natin, Municipality of Tangkal. Is Municipality of Tangkal considered as a Muslim? Oh, balik tayo. Balik tayo sa formula natin. Yung government natin, di ba? Oh, government, sa baba niya. Anong dapat i-further niya na interest? Secular or sectarian standard? Secular interest. Can it further or can it advance a sectarian standard? No. Question. Ano ang local government unit of the municipality of Tangkal? Is it a government instrumentality? Yes. If it is a government instrumentality, what interest should it further? What interest should it advance? It is secular interest. If you give municipality of Tangkal the status of becoming a Muslim, you furthered a sectarian interest. That being the case, you cloak the city or the municipality of Tangkal a religious sector. Therefore, you are actually advancing this sectarian interest. Is that allowed? No, because that's already a violation of the establishment clause, the prohibition on the establishment clause of the Constitution. Question. Another reason. Para maging Muslim, that should be personal. Can you lend this personal law into this artificial entity created by law? The answer is no. Okay? So tingnan nyo ha. Bumalik ka dun sa ating framework. Secular versus sectarian. Unfortunately, Municipality of Tangkal cannot be given the status of becoming a Muslim because It furthers a sectarian interest. Are we clear of it? Yes. Okay, another doctrine. Balik kayo. Doon sa Inre Valenciano, 2017 case. Remember? May mga prayer meetings, the mass na kinakandak at around 12 o'clock to 1 o'clock doon sa Hall of Justice. Okay, ang tanong doon is whether or not the state can accommodate that religious practice. Sagot ng court, yes. Why? Ang tanong lang naman, may na-violate ba na secular standard? Sagot, wala. May ginawa ba ang state? Meron bang positive action ng state to advance the sectarian interest? The answer is no. So, ano yung doctrine na ginamit? Yung doctrine of accommodation of this religious exercise. Go back. Did it advance a secular standard? Wala. Did it accommodate the religious belief? Yes. Did it advance a sectarian interest? It does not. Bottom line, it only accommodated this religious belief. So that being the case, inallow ng Supreme Court. Oops! You know, again, there's a dissenting opinion of Justice Marvick Leonen. But of course, we focus on the majority opinion. Ang sabi ng Supreme Court doon, it's only the doctrine of accommodation po. Okay, so make no mistake about it. Now, of course, one of the ruling, we have Estrada versus Escritor. Anong sabi ng court doon? Using the benevolent neutrality approach, the doctrine there is still the doctrine of accommodation. Okay, it only accommodated the religious exercise of Escritor. Okay, so those were the doctrines na, pansinin nyo, ang iniikutan lang, secular versus sectarian interest. Okay, so, nasundan nyo ba? Okay, kung nakakasunod kayo, baka naman pwede mag-comment lang kayo sa baba ng comment section natin. Ilagay lang doon, VLC. Tapos, smiley ko. Okay? Pag inaantok na kayo, tawa lang ng tawa dyan. Okay. Now, ito. Another issue. This is one of the perhaps controversial case din po. No? The case of Madrilejos. Wrong spelling. Madrilejos versus Gatdula. September 24, 2019. Okay. Now, here's the issue in this case. Okay. Ito ho yun. Ang issue dito, simple. Meron kasing city ordinance yung nagde-define ng mga pornography and the like. So, yung mga petitioners, dinimanda ngayon itong mga akusado. Ang contention nila is that there should be a criminal information to be filed against them on the ground, yung mga grave scandal, yung obscene publications, and a violation of the ordinance. Okay? So, ang problema, nung umakyat sa Supreme Court, okay, na-dismiss itong mga na-dismiss na yung mga final doon sa preliminary investigation proper pa lang. Ang tanong ngayon is, pwede bang i-rule ng Supreme Court kahit na na-dismiss na yung final na kaso sa Office of the City Prosecutor? Okay. So issue here is simple. Is it already moot and academic, or is there an exception for the court to entertain and adjudge the case on the merits? Kasi syempre, wala na yung actual case or controversy dito eh. Moot and academic naman na talaga eh. Kasi na-dismiss na nga yung pinaglalaban nila. They are questioning, the petitioners here are questioning whether those provisions in the law, the revised penal code and the ordinance, are considered as unconstitutional for being overbroad. And of course, sinasabi nila na it suppresses their freedom of expression. Yun ho yung issue doon. Diba? Ang tanong ngayon, simple. Meron bang rason para i-entertain ng Supreme Court yung ganong klaseng petition? Will the Supreme Court carve out this case as an exception to the moot and academic principle? Now, one of the principles na ini-invoke nila is that it is capable of repetition yet evading judicial review. That was actually their contention. The question now is simple. Is it really capable of repetition yet evading review? Okay, so I want to share the slide to you para makita niyo yung standards na inadapt ng Supreme Court. They adopted the separate concurring opinion of Justice Prion. Okay, in one of the earliest cases, one of the early cases. The duration of the challenge action must be too short to be fully litigated prior to its cessation or expiration, and there must be reasonable expectation that the same complaining party will be subjected to the same action. Unfortunately, the Supreme Court is not convinced. Okay, the Supreme Court was not convinced na nasatisfy yung dalawang elements na to. Why? Because according to them, na-dismiss na yung kaso. And the proper thing or the proper remedy, kung hindi na-dismiss yung kaso, is for them, okay, to justify their defense by using the Miller standards. Okay? So, inadapt natin yung Miller standards, the Miller versus California case, no? Okay. So, in the Miller versus California case, under the circumstances, the proper recourse of the petitioners would have been to go to trial and to allow the regional trial court as a trier of fact to judicially determine whether materials complained of as obscene were indeed proscribed under the language of Ordinance Number 7780. So in short, gamitin yung Miller standards as part of their defense. Pag pumasok sila, okay, pag nasatisfy yung Miller standard, then, okay, papasok siya as unconstitutional. Pag hindi, o di hindi rin po. Okay? Isa pa sa mga procedural na diniscuss ng court dito is that you cannot use this facial challenge test on this specific law. Why? If you study the Ordinance 7780, ang nakalagay kasi doon is define yung obscenity, tapos sa baba niya, dun sa later provisions, merong penalty clause. Okay, so doon na, di ba? Ang tanong natin ngayon, simple. Pag may penalty clause, if it defines the nature of the crime and treats the nature of the crime and attaches the penalty thereof, anong tawag doon? That's a criminal law, right? Question. Is facial challenge test on the ground that it is overbroad applicable to this criminal law? The Supreme Court have already answered that. Remember the case of Estrada versus Desierto? Yung plunder law nun, di ba? Anong sagot ng court? It does not apply to, okay, penal laws. Okay, now I have to clarify here again. This case of Madrilejos is not without any dissenting opinion. Okay, ang sabi kasi nung iba, Justice Marvic Leonen tapos si Justice Perlas Bernabe, ang sabi ho nila is precisely the reason kung bakit ito ginagamit is to question yung freedom of expression. So pag may penal provision doon, tapos question mo yung freedom of expression, dapat mag-prosper yung facial challenge test and the overbroad challenge, no? So, here's the point. The Supreme Court have said that obscenity, yung majority opinion, obscenity is an unprotected speech. That being the case, the facial challenge on the ground of overbroad is also not applicable. Okay, so maganda yung hypothetical argument, no? Hindi siya applicable kasi penal law siya. At kahit na applicable siya, hindi siya mag-apply kasi obscenity yung issue dito. Pag obscenity yung issue dito, what's the end result? It is an unprotected speech. Okay? So that was the ruling of the court in the case of Madrilejos versus Madrilejos versus Gatdula. Okay. Now we move on. In the case of Nicolas Levis versus Comelec. Again, klaruhin ko lang ha, iba ito yung tungkol dun sa overseas voting. Iba ho ito. Okay, this is decided by the court in August 14 of 2019 through Justice Reyes Jr. The law in question is this. Okay, tignan nyo yung section 36.8, this provision. Okay, so, ang nakalagay dito sa section 36.8 is for any prohibited action dito, is for any person to engage in partisan political activity abroad during the 30-day overseas voting period. Now, I have to emphasize this, partisan political activity. Sir, bakit po? Why do you have to emphasize this? Because that is actually the index of contention, the basis of contention of the petitioners here. Ang sabi ng petitioners dito, yung partisan political activity amounts to censorship. If you prohibit the same, it amounts to censorship. Why? Because according to them, it is already a content-based, okay, regulation. Yun yung yung contention nila. Unfortunately, the Supreme Court did not decree with validity their contention. But, of course, the Supreme Court declared that this provision is still unconstitutional, but on a different ground. Why? Una, is this a content-based or a content-neutral regulation? Take it from there. Partisan political activity. Ang sagot ng court, yung partisan political activity is not, I repeat, not a content-based regulation, but a content-neutral regulation. So, pag content-neutral regulation, ano yung standard na kailangang ipasa ng gobyerno? Remember, the intermediate test. Okay? So, kailangan mag-produce, okay, ng substantial governmental interest ang gobyerno para ma-satisfy yung intermediate test. Okay, konting recap. Kapag content-based, okay, you have to use the strict scrutiny test. Correct? Okay, so paano naman kapag yung ganito, intermediate lang? Meaning, means and mechanisms lang naman yung nire-regulate nila. So dapat intermediate test lang po yung ginagamit. Okay, balikan natin ha. Remember yung mga IUTAC case versus COMELEC, the adjunct versus COMELEC, all of those are content-neutral regulations. Okay, ang tanong dito, if you want to use the intermediate test, pumasa ba sa O'Brien's test itong mechanism ng ng Republic Act 10590? The Supreme Court answered in the negative. Why? It's because, according to the Supreme Court, okay, a governmental regulation, you look at your screen, okay, a governmental regulation is sufficiently justified if it is within the constitutional power of the government, pasok. If it furthers an important or substantial government interest, or if the governmental interest is unrelated to the suppression of the freedom of expression, and if the incidental restriction on the alleged freedom of expression is no greater than that is essential to the furtherance of that interest. Saan nayari yung batas? Nayari sila dun sa last provision. Okay? No greater than essential to the furtherance of that interest. So, ang sabi ng court, that provision is overbroad. Why is it overbroad? Because it sweeps onto those constitutionally protected freedoms. Okay? So, that being the case, the Supreme Court decreed that provision of the law as unconstitutional. Okay? So, ano yung ground niya? For failure to pass the intermediate test, more particularly subsection 4 thereof. Okay? So, please take note of those cases. Okay, now, we move. Ito maganda. Another issue, the freedom of the press issue. Okay, so I hope gising pa tayo ha. So pag halimbawa, inaantok-antok kayo, galaw-galaw lang ko dyan, tapos tawa lang ko ng tawa. Okay, so please take note ha. Okay, so the next case is Tordesillas versus Puno. GR number 210088, October 1 of 2018, Justice Tiham. Okay, just to give you a brief background. Remember the Manila Pen standoff? Diba? Nung nag-issue kasi ng warrant of arrest for purposes of enforcing the direct contempt charge against Senator Trillanes. Nag-issue si Judge Pimentel, Judge Oscar Pimentel, one of the most famous criminal law reviewer. Okay? Nasa VLC din po siya. No. Ang nangyari ho, ganito. Nung na-issue yung warrant of arrest doon, of course, pumunta yung mga members ng media doon sa Manila Pen. Unfortunately, no, hindi nila ni-receive yung warrant of arrest. Ang danger dito, may mga personals ng media na nandun sa loob. Merong gustong gawing parang military action. So nag-issue ngayon ng memo, ng advisory, itong si DILG Secretary Puno. Okay, so sabi nga doon, pwedeng mademanda na obstruction of justice yung mga media personnel na nasa loob simply because ayaw yung lumabas for that reason. Siyempre, may mga gagawin daw silang mga moves and steps. No. So, here comes now Tordesillas and her courts asking the Supreme Court to nullify the action of the DILG Secretary Puno on the ground that it infringes the freedom of the press. Okay, how did the court rule on the matter? The simple reasoning of the court is that there is no suppression of the freedom of the press. Why? It's because according to the Supreme Court, okay, excuse me, No media network or personnel is prohibited nor restricted from reporting or writing on any subject matter or from being present and covering newsworthy events, unlike the advisories, resolutions subject of the cases above cited. So there is no really suppression of the freedom of the press because they can still perform their functions. That being the case, the Supreme Court debunked, okay, the petition of Tordesillas. Okay, now, next case. Ito, yung ruling ng court through Justice Peralta sa case na to, consistent, okay? But I just would like to emphasize the consistent view of Justice Marvic Leonen in his dissenting opinion in every libel case presented to the court. This is the case of Belen versus People. Okay, ganito ha. Klaruhin ko lang. Consistent naman yung ruling ng court sa libel, so I will not dwell into that. I will dwell on the separate opinion or the dissenting opinion of Justice Leonen. Look at the phrase. The libel provisions under the revised penal code invade a constitutionally protected freedom, imposing both criminal and civil liabilities to the exercise of free speech produces a chilling effect. Okay? So, the impression that is given by Justice Marvic Leonen is consistent. Sabi niya, libel should not be criminalized. Okay? So, I just would like to emphasize that. No. Ang gusto ko lang gawin nyo is, siguro balikan nyo ng konti yung mga libel cases this coming 2021 bar exams. Why? For obvious reasons. That is the consistent view of your bar chairperson. Okay? So, sana lumabas yung mga ganitong klaseng kaso para kahit papano makatulong naman tayo dun sa mga next in line lawyers. Okay? So, okay. We go back with this another important ruling of the court in 2017. Lumabas na po siya noong 2018 bar examinations po, no? And 2019 bar exam, and this is the one penned, of course, by Justice Perlas Bernabe. Okay, you remember this case, Spark versus Quezon City. Okay, what was the case? What was this case all about? Remember the curfew hours imposed by the different local government units. We have yung Quezon City, Manila, and the like. Now, ang issue dito, is it constitutional or not? Okay? Is it constitutional or not? Okay. Yung dalawa was declared as unconstitutional. Yung isa, lumusot, constitutional. Anong pinagkaiba? Okay. Ito yung point. There are several rights that are actually restricted and regulated by this city ordinances on the curfew hours. Ang issue lang doon is whether or not these constitutionally protected rights are still protected by those city ordinance. So paano mo titingnan yon? Malalaman mo yan on the exception clause of the ordinance. Okay? Kapag maprotektahan yung mga rights na yon on the exception clause, then it can pass the test of constitutionality. So, pag halimbawa, binan mo lang, nagkaroon ka lang ng curfew, nagkaroon ka lang ng ordinance na nag-set ka ng curfew. Tapos wala kang ginawa to protect those rights. Paano yung mga mag-aaral ng gabi? Paano yung mga magsisimba ng gabi? Paano yung mga inutusan ng nanay paggabi? Okay? Paano yung mga gustong mag-rally paggabi? Those are constitutionally protected rights. So, pag walang exception clause to accommodate those rights, then that is unconstitutional. Why? Two grounds. Okay, two important reasons rather. This curfew hours is actually a form of the exercise of the state in its parens patria. Diba? Under the doctrine of parens patria, pwedeng protektahan ng state yung mga vulnerables. Now, the issue here is very simple. Ito bang mga gustong protektahan na to, okay, is also protected by the very regulation imposed by the state. Okay? So, yun yung tanong. Kasi, you're regulating it eh. So, essentially, you're invoking the police power of the state. And you have to test the lawful end and the lawful means test. Does it have a lawful end? Obvious reasons, yes. Does it have lawful means? The answer is no. Why? Because this means instituted did not in any way protect, okay, those constitutionally enshrined rights, okay, under the Constitution. Constitutionally enshrined rights in the Bill of Rights, rather. So, dapat may mga exception clause to accommodate this. Okay? So, congratulations to Quezon City. Kasi, yung ordinance nila, pumasa. Bakit pumasa? Because sa exception clause nila, nandun yung mga mechanisms in order to protect those constitutionally protected rights. Yung dalawa kasi, na declare na unconstitutional because it is too overbroad. Yun na yung point. Hindi mo prinotektahan yung constitutionally protected freedoms. So, it sweeps to the extent of not protecting the same. So, it was declared as unconstitutional for being overbroad and indirectly an invalid exercise of police power. Okay. So, that's his part. Lumabas na siya. So, posible bang lumabas? Sana nga, sana. sana lumabas. Okay. Now, we go now to another controversial issue. Yung mga nagpahirap, magpasalamat tayo at hindi tayo naabutan ng K-12. Kasi kung naabutan tayo ng K-12, nadagdagan na naman tayo ng 2 taon. No? Okay. Anyway, so this is the case of Conference Council of Teachers and State Colleges, Universities of the Philippines, COTESCUP versus Secretary of Education. Okay. First question, is K-12 constitutional? Now, one of the grounds that were invoked here is this. Okay, hindi mo sila masisi. Di ba? Kasi, isa sa pinaka-importanting element kapag merong administrative issuance is that kailangan mag-comply ka sa Book 7 ng Admin Code. So, in short, kailangan i-publish mo. Tama? Ang tanong, na-publish ba or hindi? Okay, second question. Kailangan ba siyang i-publish or hindi? Okay? Make no mistake. This is a department order issued by the Department of Education. Department Order number 31. Okay, question. What's the nature of Department Order number 31? Okay, kukontrahin ko muna ha. One of the arguments of the petitioner is that this this department order issuance of DepEd is unconstitutional for what ground? Number 1, it adds burden to the general public. Hindi mo masisi. Because in the ruling of the court in De Jesus versus COA, kapag nag-add ng burden yan sa general public, it needs to be published. That's correct. Unfortunately, in this case, the Supreme Court have said, this Department Order number 31 did not add burden. Okay? As a matter of fact, it is only construed by the court as an internal regulation. So, kapag internal regulation lang siya, tingnan nyo ho, it is only an administrative or internal regulation addressed to DepEd personnel. Okay? So, for providing general guidelines on the implementation of the new curriculum for grades 1 to 10 in preparation for K-12. So, ano sinabi ng court dito? Maliwanag. Just to debunk the De Jesus case, no? It did not add burden. The subject of this regulation are those personnels under DepEd. So, it's an administrative regulation. That being the case, it is not required to be published. Okay, now, I admired the Secretary of Education. Why? It's because kahit na ang belief nila is administrative regulation yan, nag-comply pa rin siya. It was deposited, okay, dun sa National Administrative Register natin sa UP. So nag-comply pa rin siya dun sa publication requirement under the Administrative Code. So, di ba supposedly moot and academic na. But for purposes of judging the case on the merits, the Supreme Court have said that it is only an administrative regulation. That being the case, it is not needed to be published before, okay, the UP National Administrative Register. Okay, so UP honor natin. Okay, so that's one of the issues that were raised in that case. Okay. Okay. Of course, this case is the one close to my heart because I am actually a nurse, a nurse by professions. Pero pag tinignan mo yung mukha ko, parang hindi nurse na. Okay. Anyway, so gising pa ba tayo? Huwag kang mag-alala, konti na lang. At pagtsagaan mo na ng konti yung pagmumukha ko. No? Alam mo, kahit na hindi kita na personally nakikita, may feeling ako pag nag-joke ako, hindi ka gaanang tumatawa. Pero pag nilalait ko yung sarili ko, tuwang-tuwa ka. Okay, normal lang ho. Anyway, so we go now to the next case. This is the one close to my heart. Ang NARS party list versus executive secretary. Okay. Now, this case is all about the power of Congress, the joint power of Congress and the president in making a law versus the joint power of Congress and the president in amending a law. Okay. Now, ganito ho yung issue. Kukwento ko yung background para makita nyo kung bakit nagkaroon ng mga contentious issue dito. I will go back with the early case of Galicto versus Aquino. I will not go to the majority opinion kasi syempre na-dismiss siya on the ground na walang legal standing doon. No? But I will focus on the separate concurring opinion of the late Chief Justice Corona. Sa separate concurring opinion of Chief Justice Corona, the late Chief Justice have mentioned that the joint resolution is a law. I repeat, the joint resolution subject of that Galicto versus Aquino was considered to be a law. Therefore, it can amend a previous law. Okay? That was one of the separate concurring. It's not part of the majority. It's part of the separate concurring opinion of Chief Justice Corona. Now, we go to the case of ang NARS party list. Under Republic Act 9173 or the Philippine Nursing Act of 2002, the entry salary grade for nurses is salary grade 15. Yun yung nakalagay. Now, yung salary grade 15 na yon, okay, appears to be amended by a joint resolution, okay, signed by the President. So binaba from 15, naging 10, tapos subsequently naging 11. So the question now, reiterated by the ang NARS party list group, represented of course by our president, by our congressman before, and the former president of Philippine Nurses Association, si Ma'am Imelda Samaco Pakis. Ang contention niya simple lang. Can a joint resolution amend Republic Act 9173? Okay, that was the contention. The Supreme Court have said that that resolution cannot amend Republic Act 9173. Why? I have to emphasize, majority of the provisions of the 1987 Constitution are lifted from the US Constitution. So, yung interpretation ng US Constitution by the Supreme Court of the United States has persuasive effects sa atin. Okay? We have copied substantial provisions from the US Constitution, but not all. Justice Carpio highlighted that. Not all provisions of the US Constitution were copied. Okay? Now, I want to highlight this. Sa atin kasi, what can become a law? Bill can become a law. What can be vetoed by the President? Only a bill can be vetoed by the President. In the US Constitution, the following can become a law: bill, order, resolution, or vote. Apat. Bill, order, resolution, or vote. Problema. Sa Philippines po, ano hong ginamit natin? Sa Philippine Constitution, only a bill can become a law. Okay? So, sabi ni Justice Carpio, verba legis principle po ito. We don't need to interpret, actually. We only need to apply the Constitution. So, that was the opinion of the court. Another one, Justice Carpio have said, expressio unius ex exclusio alterius. What is deemed, okay, what is not included is deemed excluded. Sa atin po, ang pwede lang maging batas, bill. Ang nakalagay sa US Constitution, yung apat. So, hindi sinali. So, it is deemed excluded. Okay. Now, Isa ito sa mga parting decisions po ni Justice Carpio. I want to emphasize one important thing here, no? Justice Kagiwa dissented. I repeat, Justice Kagiwa dissented in this decision. Ang tanong bakit? Okay, ito yon. The reasoning is very simple. Kung titignan nyo kasi, yung House rules tapos Senate rules, there is no distinction between a resolution and a bill. I repeat, there is no distinction between a resolution and a bill. Another one. Nung trinak-down kasi nila yung history nitong Joint Resolution number 4, nakita nila na yung document na to nagdaan din sa separate reading. Except that, hindi nag-comply sa 3 separate, it was certified by President Gloria Macapagal Arroyo. May question ako. Di ba parang bill din ho yung pagka-treat ng resolution na yon? Tama? Okay. So of course, I'm just re-echoing the dissenting opinion of Justice Kagiwa. But of course, the Supreme Court have said through Justice Carpio, again, verbalize his principle, what can become a law, it's only a bill. Hindi kasali ang order, hindi kasali ang resolution, hindi ho kasali ang vote. So I hope that's clear. Again, another doctrine, expressio unius est exclusio alterius. Okay? So those are the updates that we have in political law. If you have any questions about it, just feel free to comment in the comment section, and please do type VLC if you're enjoying and if you're listening attentively to our lecture. Please don't forget to comment and subscribe to Villasis Law Center. Okay, so siguraduhin nyo lang po para updated kayo sa lahat ng information. Now, as last part of our lecture, I just want to say a few words about taking the bar exam. Alam nyo, there are 3 parts of taking the bar. The first part is, of course, your law school. Second part is we have your bar exams. And the third part is, of course, yung pinakamahirap, the waiting period. Okay. So, I understand the frustration. Yung mga hindi nakapag-bar ngayong taon na to. Kasi ang feeling nila, kahit na bukas na yung bar exam, ipapasa ko yan. Di ba? So parang madidelay lang ho yung pagiging abogado ninyo. But I always say, everything happens for a reason, no? And one of the few favorite words na nakukuha ko dun sa mga magagaling kong mga mentors is that what happens is not as important as how you react to what happens. So I hope maging reactive tayo. Ngayon, dun sa first part ng pag-take ng pagre-review for the bar, yung law school ninyo, yung mga graduate na, wala na tayong magagawa. Tapos na yan. Yung mga sumali sa discussion natin na nasa law school pa lang, I hope magising tayo sa katotohanan. Dito or ito yung best time para umpisahan maging abogado during your law school. Doon sa actual bar, sa bar exams, ito yung preparation natin doon sa bar, mahirap po ito. Why? It's a dedicated 6 months. It's as if you treat the bar exam as part of your, one of the most important thing in your life. Sa totoo lang, mas importante pa yan kaysa sa buhay nyo, di ba? Di ba? Oh, I'm not kidding. Di ba? Pag sinabi nila, mamatay ka man, di ba? Bumagsak ka man sa bar exam, ay, ibang usapan yan. Di ba? So, iba kasi talaga yung impact ng bar exam. But one thing is for sure, dun sa pagre-review mo, at sa pag-take mo ng bar, you can use your will. W-I-L-L, will. Pagkatapos ng bar exam, tapos na yung will. Wala ka na magagawa dyan. Dyan papasok yung hope. So sa first stage, you have your will and hope. Sa second stage, you have your will and hope. Sa last stage, you only have your hope. Then papasok yung pagiging religious mo. Then papasok yung positive thinking mo. I urge you, as long as you have the will, use it. Don't have a lot of regrets. Because as the earlier saying goes, you don't have the right to regret some things that you haven't done. You only have the right to regret those things that you have done. So it's better to do it. But my personal take, don't just do it. Excel in everything that you do. You have to. Don't think of those persons who believed in you. Think first of yourself. Because it's really you who knew what you really want to become. Always remember, yesterday, you're just nobody. Today, you're nobody. But someday, you will be somebody. Guys, before I leave this lecture series of VLC, I would like to leave 2 letters and 1 word. It's a capital N and O and the word no. Say no. Say no to failure. Say no to everybody else. Say yes to only one. And you know what's that one? Other than God. Say yes to yourself. Because it's really you who knew what you really want to become. Okay, God bless you. And see you all. Thank you for watching and staying until the end of the presentation. Please visit the VLC website at www.villasislawcenter.com to know more about the virtual law companion. Prepare for the bar examinations at anytime, anywhere, and from any mobile device. Together, we can. You only need VLC, yourself, your will. So you will have your appointment with destiny and a date with history. Thank you, and God bless you all.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
In Spouses Minjola Gulis Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised
embark on a retrenchment program only if it was experiencing actual losses. Not necessarily. In the words of the Supreme Court, if the employer can perceive that sooner or later the economy of the company will go down to the drain, then it should do something. The employer of the company should do something. It should not wait anymore for that time or period that the employer or company incurs actual losses.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
What is our definition of the practice of law? We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is